Think being pope means absolute freedom? Think again. From never stepping down to bizarre body ownership rules, the leader of 1.4 billion Catholics faces restrictions that would shock most believers. Some stem from divine law that even the Holy Father cannot change, while others are centuries-old traditions locked in place. Here are 15 weird facts you didn't know about what the Pope is not allowed to do. Fact 1. Cannot ordain women as priests. The Pope, despite being the supreme pontiff and leader of over 1 billion Catholics worldwide, lacks the authority to ordain women as priests. This isn't simply a matter of church tradition or conservative policy that could be changed with a signature, but rather what the Catholic Church considers divine law established by God Himself. In 1994, Pope John Paul II issued an apostolic letter called Ordinatio Sacerdotales, which definitively declared that the Church has no authority whatsoever to confer priestly ordination on women, and that this judgment is to be held by all the faithful. The document explained that this restriction comes from Christ's choice to select only men as His 12 apostles, a decision the Church views as divinely intentional rather than culturally influenced. What makes this particularly unusual is that even if a future pope personally believed women should be ordained, he would be bound by this declaration as a matter of faith. The restriction goes beyond papal preference or church policy into the realm of what Catholics call the deposit of faith, meaning truths revealed by God that cannot be altered by human authority. This creates a paradox where the most powerful figure in Catholicism is simultaneously powerless to change this specific rule. Various theological arguments have been made about whether this is truly divine law or changeable church discipline, but the official position remains firm. The Pope can change canon law, create new saints, reorganize dioceses, and even modify ancient liturgical practices, yet this one area remains completely off-limits, regardless of how the world changes around the Church. It's a reminder that papal authority, while vast, has very specific boundaries that even the successor of St. Peter cannot cross. Fact 2. Cannot be judged by anyone. In one of the most extraordinary legal protections in human history, the Pope cannot be brought to trial by any person, court, or governmental body on earth. This principle was formally defined at the First Vatican Council in 1870, which taught dogmatically that the Roman Pontiff holds supreme jurisdiction over the entire Church and that no one can pass judgment on him. The Latin phrase prima sedes a nemine judicatur translates to the first see is judged by no one, establishing that the Pope answers only to God. This means that even if a pope were accused of criminal activity, heresy, or gross misconduct, no earthly tribunal would have the authority to prosecute him. The International Criminal Court cannot touch him, national governments cannot arrest him, and even a council of bishops lacks jurisdiction to put him on trial. This protection extends beyond just religious matters into all aspects of papal conduct, creating a situation where the Pope exists in a unique category of absolute immunity. Historically, this principle developed partly in response to medieval conflicts when emperors and kings tried to depose popes they disagreed with, but it remains in full force today. The only recourse for a pope who commits serious wrongdoing would be his voluntary resignation or divine judgment in the afterlife. Some canon law scholars have debated whether a heretical pope loses his office automatically, but even this theoretical situation provides no mechanism for anyone to formally judge or remove him. It's worth noting that this immunity is not personal but attached to the office itself, meaning the moment a pope resigns or dies, he can theoretically be held accountable for actions taken before becoming pope. This creates one of the most powerful positions of legal immunity in the modern world. Fact 3. Cannot donate his organs after death. When a pope dies, his body cannot be used for organ donation, no matter how many lives it might save. This unusual restriction exists because, according to Vatican tradition and theology, the pope's body belongs to the entire Catholic Church rather than to himself as an individual. Church officials explain that the papal body must remain intact for proper burial and veneration, as it housed the soul of Christ's vicar on earth. After death, the Pope's body undergoes specific rituals, including being displayed for the faithful to pay respects, photographed for historical records, and eventually buried in a specific location within Vatican City, usually beneath St. Peter's Basilica. The Church considers the papal body itself a kind of relic, something deserving of reverence and preservation rather than medical dissection. This stands in contrast to the Church's official position on organ donation for ordinary Catholics, which has been encouraged by recent popes as an act of charity. Pope John Paul II and Pope Benedict XVI both spoke favorably about organ donation as a profound way to help others after death. Yet neither could participate in it themselves. The restriction extends to any kind of autopsy or medical examination beyond what's absolutely necessary to certify death. When Pope John Paul II died in 2005, his body was embalmed using traditional methods but underwent no organ harvesting or tissue donation. Vatican insiders have explained that separating the papal body's organs would be seen as disrespectful to the dignity of the office and would interfere with centuries-old burial traditions. This creates an ironic situation where the Pope can encourage Catholics to donate organs but remains prohibited from practicing what he preaches due to his unique status within the Church hierarchy. Fact 4. Cannot own personal property. Despite residing in a palace filled with priceless art and having access to vast church resources, the Pope is technically barred from owning personal property. Everything a pope uses during his reign, from his ceremonial robes to the furniture in his apartment, belongs to the Holy See rather than to him personally. This means that when a pope dies or resigns, he cannot pass along possessions to family members because he never owned them in the first place. The tradition stems from the vow of poverty taken by priests and the understanding that the Pope serves as a steward of church property rather than its owner. Upon election, a new pope essentially surrenders all personal possessions, and while the Vatican provides everything he needs, including living quarters, food, medical care through a private hospital, and even spending money for minor purchases, none of it technically belongs to him. The few exceptions to this rule include items of personal religious devotion, such as a breviary, a rosary, his priestly cassock, and perhaps a small collection of theology books, which are considered tools of his spiritual life rather than property. When Pope Benedict XVI resigned in 2013, he had to receive special permission to keep certain personal items and needed approval for his retirement residence arrangements. The Vatican Bank manages all financial matters for the Pope, and any gifts he receives become property of the Holy See. This creates an unusual situation where the leader of one of the world's wealthiest organizations lives without personal wealth or the ability to accumulate assets. Even the famous Pope-mobile, the specially designed bulletproof vehicle, belongs to the Vatican fleet rather than to the individual Pope who rides in it during public appearances. Fact 5. Cannot dissolve a ratified consummated marriage. Even with all his spiritual authority, the Pope cannot dissolve a marriage that has been both ratified in the Church and consummated by the couple. This represents one of the clearest boundaries on papal power because it involves what Catholics consider divine law rather than church legislation. A ratified marriage means one performed according to proper church procedures between two baptized Christians, while consummated means the couple has engaged in marital relations after the wedding ceremony. Once both conditions are met, the Catholic Church teaches that the marriage bond is created directly by God and cannot be broken by any human authority, including the Pope himself. This is distinct from annulments, which declare that a valid marriage never existed in the first place due to some impediment or defect at the time of the wedding ceremony. The Pope can grant annulments and can dissolve certain non-consummated or non-sacramental marriages through his patron privilege, but a fully valid sacramental marriage that has been consummated is considered absolutely indissoluble. This teaching comes from Jesus' words in the Gospels, stating, "What God has joined together, let no man separate," which the Church interprets as binding even on the Pope. Throughout history, this restriction has created significant political problems, most famously when King Henry VIII of England sought to dissolve his marriage to Catherine of Aragon in the 1530s. Pope Clement VII refused because the marriage was ratified and consummated, leading Henry to break England away from Roman Catholicism entirely and establish the Church of England. The restriction remains in force today, meaning even in cases of extreme hardship or royal politics, the Pope lacks authority to undo what the Church considers a bond created by God himself through the mutual consent and physical union of the couple. Fact 6. cannot marry or enter romantic relationships. The Pope cannot marry or pursue romantic relationships, a restriction that comes from the requirement that all popes must first be ordained Catholic priests, and priests in the Latin Rite must be celibate. The last married pope in history was Adrian II, who reigned from 867 to 872, well over 1,000 years ago. Adrian had been married before becoming pope, and his wife and daughter actually lived with him in the Lateran Palace during his papacy, though he maintained celibacy after ordination. Since the formal establishment of mandatory priestly celibacy in the medieval period, becoming pope while married has become impossible. The celibacy requirement means that from the moment a man enters the priesthood, he takes a vow to remain unmarried and abstain from romantic and sexual relationships for life. This vow doesn't disappear if he's elected pope. It actually becomes more binding as he takes on the role of representing Christ as the bridegroom of the church. Even if a pope wanted to marry, doing so would contradict his priestly vows and his role as supreme pontiff. The restriction extends beyond just legal marriage to include any kind of romantic relationship, dating, or intimate partnership. If a pope were to violate this by entering a relationship, it would be considered a grave scandal and breach of his sacred promises. Throughout history, some popes have had children from relationships that occurred before they took their final vows, or in more scandalous cases, after ordination. But these were always considered serious violations rather than acceptable exceptions. The rule remains absolute today, meaning any man elected pope must commit to a life without marriage, romantic love, or family life for the duration of his papacy, and indeed for the rest of his life as a consecrated priest. Fact 7. Cannot create new divine doctrine. The Pope cannot invent new religious teachings or create fresh divine doctrine, a restriction that surprises many people who assume the Pope has unlimited theological authority. This limitation was spelled out clearly by the First Vatican Council in 1870, which declared that the Holy Spirit was not promised to the successors of St. Peter so that they might make known new doctrine, but rather so that they might faithfully guard and expound the revelation already delivered through the apostles. This means the Pope's role is to preserve, interpret, and explain the existing deposit of faith rather than to add new revelations to it. Even when speaking infallibly, the Pope can only define and clarify what has already been believed by the Church since apostolic times, not introduce entirely new ideas. For example, a Pope could not suddenly declare that there are 8 sacraments instead of 7, or that Jesus had siblings, or that reincarnation is true, because these would contradict or add to the revelation given to the original apostles. The restriction ensures continuity in Catholic teaching across centuries and prevents any individual pope from reshaping Christianity based on personal theological opinions. What popes can do is develop understanding of existing doctrine, much like how the Church's teaching on the Trinity was more clearly articulated over several centuries. But the core truth had to be present from the beginning. This limitation has frustrated some reformers who wish the Pope would simply change controversial teachings on issues like contraception or women's ordination. But Church officials respond that these matters are settled by divine revelation rather than papal discretion. The Pope serves as a guardian of tradition rather than an innovator, which means his theological authority is simultaneously vast in terms of interpretation but constrained in terms of invention. Fact 8. Cannot force resignation without consent. No person or group on earth has the authority to force a pope to resign from office, a protection that ensures papal independence, but can also create difficulties if a pope becomes incapacitated or unfit. Canon law specifies that for a papal resignation to be valid, it must be made freely and properly manifested, but crucially, it does not need to be accepted by anyone. This unusual provision means the Pope answers to no one regarding the decision to step down. Cardinals cannot vote to remove him, bishops cannot pressure him to leave, and even if the entire Catholic world united in demanding his resignation, the Pope could simply refuse. The resignation must come from the Pope's own free will without external coercion or pressure. This became practically relevant in 2013 when Pope Benedict XVI became the first pope to voluntarily resign in nearly 600 years, citing his declining physical and mental strength. His resignation was valid precisely because it was his autonomous choice, announced freely and properly in a consistory of cardinals. By contrast, if a group of cardinals had somehow pressured or threatened Benedict into resigning, that resignation would be considered invalid under church law. The protection exists to prevent situations like those in medieval times when emperors or powerful families manipulated papal elections and depositions for political gain. However, it also creates a potential problem if a pope becomes mentally incapacitated, develops dementia, or suffers a debilitating stroke that leaves him unable to fulfill his duties, but also unable to resign. Canon law provides no mechanism for involuntary removal, meaning the Church could theoretically be stuck with an incapacitated pope unless he personally chooses to step down before losing mental capacity. This makes Benedict's resignation historically significant, not just because of its rarity, but because he established a modern precedent for voluntary resignation while still mentally competent. Fact 9. Cannot become pope without being male. The highest position in the Roman Catholic Church is restricted to baptized men, with no possibility for women to serve as pope. This requirement stems from the Church's teaching that priests must be male, and since the pope must first be a priest to be elected, women are automatically excluded from the papacy. Unlike many other papal requirements, which are matters of church law and could theoretically be changed, this restriction is tied to the Church's understanding of holy orders as a sacrament. Catholic teaching holds that Jesus chose only men as his apostles, and that priests serve in persona Christi, acting in the person of Christ during sacraments, which the Church interprets as requiring male priests. Interestingly, while being male is absolutely non-negotiable for becoming pope, there is technically no minimum age requirement, leading to some bizarre historical situations. The most infamous example is Pope Benedict IX, who, according to historical accounts, was somewhere between 11 and 20 years old when elected in 1032, with many sources claiming he was only 12. The young Benedict's papacy was notoriously corrupt and scandalous, and he actually sold the papal office at one point before reclaiming it, eventually serving 3 separate terms as pope. Despite this disastrous precedent, canon law still includes no minimum age for papal election. A cardinal could theoretically propose a teenage priest for pope, and if 2/3 of the cardinals agreed, the election would be valid. Additionally, the pope doesn't need to work his way up through church hierarchy, meaning someone could jump directly from being an ordinary priest to pope without ever serving as bishop or cardinal, though this hasn't happened in modern times. The combination of requiring male gender while allowing any age or rank creates an unusual set of qualifications where certain boundaries are absolute while others remain surprisingly flexible. Fact 10. Cannot join Freemasonry. The Pope is explicitly forbidden from joining Freemasonry or any similar secret society, a prohibition that applies to all Catholics but carries special significance for the papacy. The Catholic Church has condemned Freemasonry since 1738, when Pope Clement XII issued the first papal ban, declaring that Catholics who become Freemasons are automatically excommunicated. While the automatic excommunication penalty was technically removed in the 1983 revision of canon law, the prohibition itself remains in full force. In 1983, Cardinal Joseph Ratzinger, who would later become Pope Benedict XVI, issued a declaration confirming that the Church's negative judgment on Masonic associations remains unchanged because their principles are irreconcilable with Catholic doctrine. The declaration specifically states that Catholics who enroll in Masonic associations are in a state of grave sin and may not receive Holy Communion. The Church's objection to Freemasonry centers on several concerns, including the secret nature of Masonic rituals, the requirement that members take oaths of secrecy and loyalty to the lodge, and what the Church views as religious relativism in Masonic philosophy. Freemasonry generally teaches that all religions are equally valid paths to truth, which contradicts the Catholic claim that the Church possesses the fullness of divine revelation. For a pope to join Freemasonry would create an impossible contradiction, as he would be pledging loyalty to a secret organization while simultaneously serving as the supreme authority of the Catholic Church. Historically, some conspiracy theories have claimed that certain popes were secret Freemasons, but these claims lack credible evidence and would constitute such a serious violation that the pope's election might be considered invalid if proven true. The ban extends beyond Freemasonry to other secret societies with similar structures, ensuring that the pope remains free from any competing loyalties or hidden obligations. Fact 11. Cannot be removed for incapacity. Canon law makes no provision whatsoever for a pope being removed from office due to incapacity caused by mental or physical health problems, and it doesn't specify which body would even have the authority to certify that a pope is incapacitated. This creates a potential constitutional crisis scenario where a pope could become severely mentally impaired, unable to fulfill his duties, yet remain in office indefinitely because no mechanism exists to remove him. Unlike many democratic governments which have procedures for removing incapacitated leaders, such as the 25th Amendment to the United States Constitution, which allows for presidential removal due to inability to discharge duties, the Catholic Church has no equivalent safeguard for the papacy. If a pope developed advanced dementia, suffered a major stroke, or fell into a coma, he would technically remain pope unless he had previously resigned or unless he died. Even more problematic, there's no agreed-upon authority who could officially declare a pope incapacitated. The College of Cardinals cannot vote to remove him. Bishops have no jurisdiction over the pope, and Vatican doctors would have no legal authority to certify incapacity in a way that triggers any removal process. This became a practical concern during Pope John Paul II's final years when he suffered from advanced Parkinson's disease and was visibly struggling to perform basic papal duties. Many observers questioned whether he should resign, but since he never chose to do so, he remained pope until his death in 2005. The situation was handled through informal arrangements where cardinal assistants took on more responsibilities. But there was no formal legal framework governing the transition of power during his illness. This gap in canon law represents a significant vulnerability in church governance, as it theoretically allows for a situation where an incapacitated pope remains in office while unable to lead, with no clear mechanism for ensuring the church's continued effective operation. Fact 12. Cannot speak infallibly on non-doctrinal matters. Contrary to popular belief, the Pope cannot speak with infallible authority on just any topic, but only on specific matters of faith and morals when speaking under very particular conditions. Papal infallibility, defined at the First Vatican Council in 1870, applies exclusively when the Pope speaks ex cathedra, a Latin term meaning from the chair, referring to his role as supreme teacher of the Church. For a statement to be considered infallible, the Pope must explicitly indicate he is defining a doctrine concerning faith or morals that must be held by the whole Church. And he must be speaking in his official capacity as successor of St. Peter, rather than as a private theologian. This means that papal encyclicals, which are formal letters to the worldwide Church, are not automatically infallible unless they meet these strict criteria. Similarly, papal interviews with journalists, casual remarks to visitors, homilies during Mass, tweets from the papal Twitter account, and even formal speeches to international bodies are all considered non-infallible teaching unless the Pope explicitly invokes his full authority to define doctrine. In fact, throughout the entire history of the papacy, infallible statements have been used remarkably rarely, with most scholars agreeing on only 2 clear examples since the doctrine was formally defined: the dogma of the Immaculate Conception in 1854 and the dogma of the Assumption of Mary in 1950. This means that when Pope Francis makes statements about climate change, immigration policy, economic systems, or other contemporary issues, he is offering authoritative guidance that Catholics should respect, but not infallible teaching that demands absolute assent. The Pope cannot declare scientific facts infallibly, cannot make infallible judgments about political questions, and cannot use infallibility to settle historical disputes. The restriction ensures that papal infallibility remains limited to core theological truths, rather than extending to every opinion the Pope expresses. Fact 13. Cannot have minimum age requirement enforced. While becoming Pope requires being a baptized Catholic male, There exists no minimum age requirement in canon law, leading to one of the most bizarre episodes in papal history. Pope Benedict IX was allegedly elected in 1032 at approximately 12 years old, making him by far the youngest pope in history and demonstrating that even children are theoretically eligible for the papacy. Benedict's family, the powerful Tusculani counts, essentially bought the papal office for him through bribery and political manipulation. His reign was predictably disastrous, marked by allegations of sexual misconduct, violence, and rampant corruption. According to historical records, Benedict eventually sold the papacy in 1044 to his godfather, who became Pope Gregory VI, making Benedict the only pope to have sold the office. He later reclaimed the papacy through force, was driven out again, and then returned for a third reign, serving 3 separate non-consecutive terms as pope. Despite this catastrophic precedent clearly demonstrating why child popes are a terrible idea, the Church never established a minimum age requirement. Current canon law simply states that any baptized Catholic male can be elected pope without age restrictions. While modern papal elections exclusively consider elderly cardinals who have spent decades rising through church ranks, technically, the College of Cardinals could elect a teenage priest if they chose to do so. The absence of an age requirement also means there's no mandatory retirement age, allowing popes to serve until death regardless of how elderly or infirm they become. Pope Benedict XVI's resignation at age 85 in 2013 was revolutionary, partly because he chose to step down while still mentally competent rather than serving until death. The lack of both minimum and maximum age requirements creates an unusual situation where papal qualification focuses on gender and theological orthodoxy while leaving age entirely to the discretion of the electors. Fact 14. Cannot require only Latin and Italian. In a surprising linguistic limitation, the only 2 languages every pope must be fluent in are Latin and Italian, regardless of where he comes from or which populations of Catholics he serves. Latin remains essential because it is the official language of Vatican documents, church legislation, and formal communications, while Italian is required because the Pope governs Vatican City as an Italian-speaking microstate and must communicate with the predominantly Italian Vatican bureaucracy. This means a pope from Africa, Asia, or the Americas must master these 2 European languages, even if they're unrelated to his native culture or the primary language of his homeland's Catholics. The requirement seems particularly misaligned with the global nature of modern Catholicism, where the majority of Catholics live in Latin America, Africa, and Asia, rather than Europe. For example, the largest Catholic population exists in Brazil, where Portuguese is spoken, yet popes don't need to speak Portuguese. Similarly, massive Catholic populations in the Philippines, Mexico, and Congo have no representation in the required papal languages. When Pope John Paul II was elected in 1978 as the first non-Italian pope in 455 years, his Polish background was less important than his fluency in Latin and Italian for conducting Vatican business. Pope Francis, elected in 2013, is the first pope from Latin America, but he was required to be fluent in Italian despite being from Argentina. The linguistic requirement reflects centuries of European dominance in church leadership, but creates practical difficulties in a globalized church. Interestingly, many recent popes have been polyglots who speak numerous languages beyond the required 2. John Paul II reportedly spoke 12 languages fluently. However, these additional languages remain optional rather than required, meaning a pope could theoretically serve while only speaking Latin and Italian, unable to directly communicate with the vast majority of the world's Catholics in their native languages. Fact 15. Cannot overturn predecessors' infallible teachings. The Pope cannot overturn or contradict any infallible teachings defined by previous popes, creating a situation where each pope is bound by the ex cathedra declarations of his predecessors stretching back through centuries of church history. When a pope speaks infallibly on a matter of faith or morals, that teaching becomes part of the permanent deposit of faith that all subsequent popes must uphold and defend. The First Vatican Council declared that what Roman pontiffs have once defined in faith and morals stands immutably and cannot be revoked or altered by any successor. This means that Pope Pius IX's infallible definition of the Immaculate Conception in 1854 and Pope Pius XII's infallible definition of the Assumption of Mary in 1950 are permanently binding on all future popes. No pope in the future, regardless of his personal theological opinions or changing cultural attitudes, can declare these dogmas null and void or reinterpret them to mean something fundamentally different. This creates a cumulative effect where the longer the Church exists, the more theological territory becomes permanently settled and beyond the ability of any pope to modify. Critics sometimes argue this makes the Church unable to adapt to new knowledge or changing ethical understanding, while defenders respond that it ensures theological continuity and prevents doctrinal chaos, where each pope could contradict his predecessors. The restriction applies only to truly infallible statements, which are rare, but it means that when popes do invoke their full teaching authority, they're making decisions that will bind every one of their successors until the end of time. This gives enormous weight to the decision to speak infallibly and explains why popes use this power so sparingly, having done so only twice since the doctrine was formally defined in 1870.